generally so opposed as to want to kill it. They just wanted to hear nothing more about it for themselves. So what happened was that the judges who were interested realized that a lot of them were doing much of this intuitively and implicitly and on a catch-as-catch-can basis. But once they were exposed to a theory, a conceptualization, a vocabulary, they realized that they could see this more readily now and could start doing it more often, and they became really the base of the reform movement. Also what happened is those who stepped up and were willing when there was a new drug treatment court or one of these special courts to serve in that, that really requires, or should require, a good grasp of and understanding of TJ and an appreciation for it. But what we found, too, is when they then had a different judicial assignment and went back to the general bench, they took this perspective with them. And that led to a further and further expansion. So a short answer to your question is I think that there is a growing group of judges who relate to this, and that they have been using it in their courts, and they've been then encouraging their lawyers to do things a bit differently, and that's how the snowball has worked. I mentioned earlier, though, the Facebook page. That's only about a year old, actually even less than a year, and the composition of it, I think, is quite different from a TJ listserv that we have. The TJ listserv is remarkably lawyers, judges, law professors, and a number of social science, social workers, psychologists, criminal justice people. But the Facebook page, I think, has that and all sorts of other general members internationally, and we don't necessarily know that much about them, but we have a 550 or so member list from many, many different countries. And it's a much broader group than the judicial law professor or law student group that was the original one. So I think, in answer to your question, I'd be saying it's changing as we speak.
Thank you.
Other comments or questions? So other comments or questions for Dave Wexler on this on therapeutic jurisprudence, and then we'll move after this one to our next question. So I want to make sure we get all the questions on therapeutic jurisprudence right now that you might have.
Aloha, this is Carrie from Hawaii, and I just have a quick question.
Yeah.
There was impressive rates in terms of repeat offender reductions on that 18-month programming, and I'm wondering who pays for that programming, and how do you secure sustained funding?
The programming is actually paid through a grant, and then what we're finding is that it's in part self-supported through the fees that the participants are paying. The participants, even though a lot of them, again, it's understood that it's a voluntary program that they choose, and of course what they're doing in a sense is being able to address their behavioral problem with alcohol, and at the same time not be dealing with a felony offense, but they are in part responsible for paying all their treatment fees and related administrative costs. So part of that, or a large chunk of the program, is actually being paid through the fees of the participants who are actually in the program, because they are paying the fees to the treatment provider to be in the program. And again, it's a minimum of an 18-month buy-in, so it's a fairly expensive process, and they also operate, for all intents and purposes, on a three-strike rule. And if you have 3 violations, and that can include but not be limited to missing appointments, being positive on a breathalyzer test, which they are subject to breathalyzer and random urinalysis all the time, breathalyzer every time they come into court, then they're subject to that 3 strikes rule. But the majority of the funding, part of it is through grant money, the majority of the funding is also through the participant fees that they collect to be part of the program.
Nice, thank you.
Okay. Other comments or questions? Other comments or questions? I know, Tom, you always have lots to say. Tom from Salisbury, did you want to pipe in or chime in on this one? Or
I can play Angel's advocate. Many of the court procedures aren't meant to be therapeutic, but punitive. How does this relate, especially to law, if it does at all, and that actually are guilty of crime excluded from this, or how system?
I'm not sure.
Tom, we're having some connection problems there. Do you want to repeat the question? You want to repeat the question? We seem to be having some. The voice is intermittent.
Oh, okay.
Thank you.
Can you hear my voice?
Yes.
Thank you, Brian. I was saying that I would like to play the angel's advocate and ask, how does this relate to the law in which and the legal system in which there are guilty parties, and especially how it would relate to criminal law, and in particular to those found guilty by the law, sometimes deservedly so. And so I'm wondering, how does TJ relate to the criminal justice system as a whole and to guilty offenders in particular?
Thank you.
Very much so. As I said before, we just look at the therapeutic and anti-therapeutic aspects of laws, procedures, roles of lawyers and judges, and even within the criminal system, which is largely punitive, you have some of these diversion programs, like you spoke of in Fairbanks, of a DUI court and those kinds of things. But in the general criminal system itself, we would hope that lawyers and judges would be aware of some amount of discretion that's there, so that even a judge, when he or she is imposing a sentence on a guilty defendant who's been found guilty and who is even going to be incarcerated, there are different ways of imposing that sentence, speaking to the defendant about that sentence, writing a series of reasons for the sentence, some of which can be devastating to someone, some of which can be rather, in the long run anyway, a bit inspirational in terms of focusing on some of the defendant's strengths and promoting kind of a readiness, say, for rehabilitation or receptivity to all of that. And since TJ really deals with the entire legal system, we're also talking about the back end, when someone is serving a sentence and then is up for, say, discretionary parole in jurisdictions where that exists. And in one of the papers that I put on the website, I have proposed a reentry moot court based on some work out of Hawaii, of Lorraine Walker's work on modified restorative circles that she's used some in the Hawaii penal system. She wrote about it. I got interested in her work and said, this could be combined with certain ideas from therapeutic jurisprudence about relapse prevention planning, about inmates having some say about what their parole plan might be, the kind of conditions that they might propose for release, do's and don'ts, for example. And then when they come up with a plan, they might actually meet within the prison before they go to the parole board with a small circle of other inmates, incarcerated persons, where the person up for parole would be presenting his or her plan to the others. The others could be acting, in essence, like parole board members, saying, well, wait a second, you said you have a gambling problem. How come you're going to be living so close to that casino? Isn't that going to be a problem? And the point of this is, of course, to strengthen the plan of the person who's going up before the parole board, doing this moot court, so that he or she will be better prepared when facing the parole board. But also, there's some generalization that's going on in learning about problem solving by the other participants, who themselves will be facing these issues soon, and who are going to be thinking through, how can my community adaptation be better, be more free of risk? What can I do? Where can I live? What kind of place might I seek employment? So that's the gist of it. So really, I think once you have this kind of TJ perspective, you try and see how it can fit in any kind of setting. And you're quite right. I mean, the criminal justice system is principally one of punishment, but even operating within there. Another aspect, I don't want to get into too much detail, but we talked about rules of law that are anti-therapeutic or less than therapeutic. Well, in a number of jurisdictions, discretionary parole has been abolished. In the federal system in the U.S., because people were unhappy with some of the differential treatment that occurred in parole, the federal government went all the way and abolished parole. They realized, however, you wouldn't just want to sentence someone to X number of years in prison and the next day have them, after they complete that term, walk out onto the street. So they substituted something called supervised release. However, the period of supervised release is imposed at the very time that one's sentence is imposed. It's not something that's earned. Your early release is not earned. And also the conditions of your supervised release, that you can't use a computer, that you can't live here, that you have to go to these meetings, all of those conditions are set at the very time that the sentence is imposed and may not really motivate anyone to think through what he or she is going to want to do 5 years from now when released from prison. So I think it's a system that is completely devoid of motivation by part of the law, from the part of the law. And a legal rule and procedure could easily be designed to try and capture more motivation for prisoners to be able to adjust better, plan better while they're in prison. So these are just examples within a very serious prison context and even with serious sentences, how TJ can play a role.
That's very good, David. Thank you. And other questions?
Brian, can I follow up?
Yes.
In that regard, David, you might be very interested. The Center for Conflict Resolution and the director for that, Dr. Brian Pokinghorn, is right here and perhaps can speak to it. Brian's waving off. Has pioneered a program with Macro in the state of Maryland to mediate prisoners who are within 6 months of release, and they actually choose the people like family members, spouses, significant others, as well as their parole officers, to mediate an agreement that they will combine expectations with the people that will be giving them support, their family, law enforcement in the case of probation officers, and then they will all sign off on this agreement so they have a mutual set of expectations in the hope that it reduces recidivism. And the program's in its infancy, so we don't have any evidence on its longitudinal value or effects, but it's something that might tie in very well with this idea of a more therapeutic and humane legal system.
It certainly sounds like it does. Is this pre a parole period? Is it some kind of mediation or agreement that's formed before someone goes up for early release, and it goes up with these kinds of agreements in place?
Well, Dan Hirko could speak to it, and Ashley. Dan, would you like to?
Sure.
Dan's work program.
It's between 12 and 18 months before their release. Can you hear me?
Yes. And if they know they're going to be released, or this program or planning might actually help and facilitate and shorten their release date, or does it not?
It won't shorten. It's more of it doesn't shorten their release date. It's more of a plan to resolve whatever conflicts that they may have prior to being released.
Okay, so it sounds very, very interesting. I would be interested in thinking of possibly doing it before one even approaches a parole board, because it may also facilitate their release. If they have this in place, if they've done this, if it shows they've engaged in this kind of planning, then a parole board might take that into account, and it might advance their release, and that would also really motivate them to really want to participate in your kind of program, I would think.
Seems like
Do you
whatever
have a
you can
reaction to
do.
that, or?
Okay,
The
Mike
program
Deku,
that, oh, I'm sorry.
no, just Mike Deku wanted to speak from Alaska, and then back to Tom. Yeah.
No, David, it seems like whatever you're saying in terms of being able to give the offender a sense of ownership or more ownership process seems to be the important thing. And, you know, playing the devil's advocate role, though, as you were talking, I was thinking to myself, okay, so are we actually putting too much discretion in the hands of the offender? And do you balance that out with developing the offender's, you know, sense of self-efficacy and taking ownership? And how do you balance that out? Because I would imagine, you know, I'm thinking about the Alaska Parole Board here, who has some very conservative folks, you know, and typically are only going to go ahead and parole about 40% of the folks who come up for it. And just thinking in terms of, you know, what their response would be to it. You know, and again, they're a pretty conservative bunch, and what they want to hear is not only the plan for you know, release or the you know, the discharge plan, but also they're real interested in coming right back to the get-go with the client, or in this case the offender, and starting from square one and having the offender basically say, you know, explain to us what you did and what what your offense was. And of course, this seems like we're taking a step right back to square one at the time of the offense, but they want to hear from the offender not only what the plan is, but in real detail what they did as a measure of taking ownership and responsibility for their behavior. So it would be really interesting when I'm thinking about it. I'm kind of going back and forth in my own head what the parole board here would how they would respond.
Well, I think those are very good questions, and I think you have different boards with different philosophies on that. It is a balance, as you say, but I think this ownership is a very, very important aspect of it, giving the person voice so that they think it's fair, and also, of course, it's their plan, not something that they're just saying to get paroled or that's imposed on them that they may, you know, resent. But if they can come up with the plan, and that's what some of the relapse prevention planning programs try and do, is have them go through, starting with the very offense that brought them there, or even earlier, and go through the chain of events that led them into criminality, and have them figure out what they can do to avoid those high-risk situations in the future, or to cope with them if they occur. And then to really come up with a plan. So I think it's not at all far-fetched even to think in the kind of moot court that I'm suggesting, that some fellow incarcerated person playing a role of a parole board will be saying, well, wait a second, how does this plan fit in with your original offense? And what are you in here for? And how are you going to make sure that you're coping with all of the issues that spring from there? So I think it's a very good point, but I think it's a balance, and I think it can be worked on.
Very good. I wanted to open up for questions from other universities, other university sites, comments or questions on therapeutic jurisprudence generally, and any particular thing you'd want to speak about.
Okay.
Brian, this is Rob Johnson at Salisbury. I just want to make a clarification on the program we were just talking about. This is for offenders who are at the end of their sentence, not necessarily parolees. And the idea is that it's a pre-release mediation where we mediate between the offender and family members so that we can clear up the conflicts that they had prior to coming into prison or while they're in prison, so that when they leave the prison, their incarceration, they have a place to go to with a supportive family network, as opposed to going out onto the streets with no place to go, or only going back to their old friends. Because recidivism, we know, the first 72 hours are the most critical. And unless there's a place they can go where they have a support system, where they have worked out the details between themselves and those people that they have offended against, that is not criminally, so to speak, but their family, extended family, their girlfriends, that's what's worked out, so that the person leaving the prison has a place to go with a clear plan of how they're going to behave, expectations laid out, and an understanding of what's going to happen, so as to reduce the chance of recidivism.
I think that's terrific, and I would love to stay in touch with you about the program and how it's working and what you're learning from it. But it does still seem to me that once you have that wedge in and have some experience there, that same program could be brought to play earlier, before a parole eligibility date and parole eligibility hearing. And my guess is all of those things are going to lead to a greater chance of parole. And I don't know what your parole system is like in Maryland, but maybe you're dealing with people at the end of their sentence because they haven't gotten paroled, and maybe they haven't gotten paroled because they haven't worked out the very issues of community adjustment and living and family reconciliation and victim issues and all of that you're dealing with.
That's a very good point. And Dan Herco and Ashley Lack Simpson are actually working a program within the penal system as part of one of the working papers that will be presented for people while they're incarcerated to work those things out. And I'll leave it to them to explain that sort of thing to you all. And we will contact you with the name of the person in charge of the program here in the state of Maryland, so you could hopefully help work it in.
Great.
I want to ask again.
All right. What I'd like to do is to move to our second question and maybe start with one of the other sites, Simon Fraser, Hawaii, and Whitehorse, to talk about what are the latest developments in mediation, victim offender mediation, conferencing, circle practices, and other practices you'd like to include. So now I'd like to open the floor up to any university, but in particular I'm thinking Hawaii and Simon Fraser, you and Whitehorse have not had much input, and you're welcome to come in. So whoever would like to speak, Brenda, maybe Brenda Morrison, would you like to talk a little bit about the school media programs?
Well, there's lots of developments here in British Columbia and Canada. In general, we use all those different types of processes in managing conflict, interpersonal and intergroup. Some of the more innovative practices, I guess, are happening using circle practices because they're less scripted than some of the other forms of restorative justice mentioned there. So the circle practices are used in a number of different places now with Aboriginal groups. We don't have a lot of circle sentencing in British Columbia. I would say the prairies practice that the most now these days, but that's still not a huge amount. Interestingly, in terms of circle sentencing, Australia uses it more than any other country at the moment. But there's many different types of mediation. So in the context of schools, schools are encouraged here in the Lower Mainland to use a whole school approach. So they could use a grab bag of any of these, and they would use a mediation process, so a peer mediation process at a targeted level. So we would have peer mediators in the playground trying to resolve disputes before they escalate. But we might also use a circle process or a conference process as an intensive, at an intensive level within the school, because the relationship structure has broken down to such an extent that we need to bring in professionals, we need to bring in mom and dad in that instance, we need to bring in some of the school personnel to work out a plan, maybe to resolve the harm done, but also to work on a plan that prevents it from happening again and keeps everyone safe in the school community. But even more important than that is the circle practices that are happening at a prevention level. Because what happens when some schools start practicing circles, the kids see it as a punishment. So they go, if you just do circles at the top end of an intervention within a school, then the kids see that as, well, I'm not getting a conventional punishment, I'm getting a circle, and it's the ooh and ah of the circle. So you want to counter that circles become a normal everyday practice in the life of the schools, and so we use circle practices to develop behavioral expectations, develop a set of values and guidelines of how we want to be in the classroom, and a lot of this centers around classroom activity because that's the center of a young person's world, particularly in elementary years. And even circles to develop social and emotional skills. So, and we know through the work of a lot of educators involved in a group called CASEL, Collaboration for Academic, Social, and Emotional Learning, is that when we give the kids the skills of social emotional engagement and relationship management, conflict resolution skills, communication skills, that the traditional outcomes of school, reading, writing, and arithmetic, actually go up because they're feeling safer at school, they have better communication skills. So we're using a range of those practices in schools here. But typically when we work with schools, we want them to start at the proactive level before we move on to the reactive level. In the case of peer mediation, what we're finding that peer mediation programs in meta-analysis from around the world, that they're only as effective as the climate that they're sitting in. And so peer mediation has to be sitting in a wider climate of relational development. So, and so we focus a lot on relationship management here in Canada. Our big bullying intervention group or Center for Excellence is called PrevNet. It stands for Promoting Relationships, Eliminating Violence. And instead of particular bullying intervention programs such as the OVEUS program, what we're finding that none of those programs are as effective as the climate in which they sit in. So we work on building a positive school climate starting at the proactive level using circles. Any questions? And we also have Erin here from Community Justice Initiatives who's happy to talk about the use of victim offender mediation in serious offense if people are interested as well. And we have someone from an executive director from one of the community accountability programs, so a community-based program that takes diversion cases from police, but can take direct referrals from the community and also works with schools. Does that help? Is that a good start?
Yes, that's very good. And so why don't we open the floor to questions from the other sites, and we'll go around the rooms a little bit, take comments and questions. Comments or questions?
On the prevention end.
Hang on, Brandon. We got some. Okay, Mike Deku first, and then we'll go to the other side. Yep.
On the prevention end, and I understand what you're saying in terms of seeing the circle processes and stuff and related things as not being perceived as punishment. But from the prevention end, are you going all the way starting from say first grade? When do you see that coming into play?
Yeah, I would encourage schools to normalize circles as early as possible. So anytime you have a class meeting at the beginning of the beginning of the school year, that you sit in circles, and we even introduce talking pieces, but we use very creative talking pieces like teddy bears. And it actually gives an opportunity for them to do different ways to do show and tell. So you can do show and tell in circles and introduce talking pieces that they bring into the classroom as a means of a show and tell, where the object that they bring in becomes a talking piece to introduce them to circle processes.
It's interesting when you're bringing that up. Just as an aside, my wife had owned and operated a preschool here in Fairbanks for about 9 years, and she literally, and again, preschool age, we're talking 3 to 5 year olds was basically the time frame, and in their circle time, that's exactly what they did. They would typically have, maybe an object from home. It might be a teddy bear, it might be whatever, but they went around and they explained, the importance of that teddy to them, or something along those lines. But in part, this is really interesting. You're talking about 3 to 5 year olds, but going back to the idea that you learn everything that you need to learn in kindergarten, it was the same kind of process, because what she was trying to do is she was trying to basically build a relationship with those 3 to 5 year olds right from the start in the preschool classroom. And typically they would be together for a 3-hour period of time, like from 9 to noon or 1 to 4, different classes. But the more she did that, it seems like, and it makes sense, the more connection the kids had, and the less discipline problems she actually had, in terms of the kids getting into just petty spats about, that's mine, no, that's mine, and that sort of thing, because they each had an opportunity to share that item as they passed around the circle and actually to say something about it. So in part, it was almost like they all had part of ownership in that, and it came off as a really positive thing. So.
Yeah, it's and in relation to those proactive circle processes or just conflict resolution process, there was a big study done in the United States a number of years ago that found that the more proactive work that you do in building healthy relationships and healthy ways to manage relationships and behavioral norms as well, that the more that you did at that, it was a combined peer mediation program with these proactive processes, and the schools that didn't get through the 20 modules of the proactive work had more peer mediation. But if you got through all the 25 modules of the proactive stuff, you didn't have to use the peer mediation as much. So in terms of a healthcare model where you have primary, secondary, and tertiary, the more that you do at the primary level, the less work you have to do at the secondary and tertiary level. With the peer mediation being a tertiary level intervention, and a full-on family group conference, for example, being the intensive or tertiary level.
Yes, we have a question from Alaska. Yes.
This is Eric from the University of Alaska. You were saying that you want to use that circle sentencing to make it seem like less of a punishment, but if it seems less of a punishment, what's to stop the person from reoffending? If they have that mindset that, oh, it's not even that bad of a punishment, why wouldn't they do it again?
It's not, in the context of schools, we don't use circle sentencing. Sometimes when schools started doing this, schools that started doing this only using a conference instead of a suspension or as an adjunct to a suspension. Some kids, because they didn't develop a normative climate around the use of a circle, it doesn't, so there's two parts to the question. They only see it as a punishment if they can't put it in a wider context. They see it as a punishment as I get a circle. No one else gets a circle. Why do I get a circle and no one else gets a circle? And because schools are face-to-face environments, kids are trying to constantly make sense of why am I getting this and nobody else is getting this. So in that comparative context, if they're getting a circle and no one else is getting a circle, there's all this metacognition going on, trying to make sense of why they're getting a circle. So it has to be placed into a wider context where relationships are formed, and it makes sense to them that I'm getting a circle, because we do circles in all aspects of school life. In terms of reducing sort of recidivism rates of using these more intensive processes at the top level, and it might be a family group conference, it could be a scripted conference, it could be a peacemaking circle process. They all can be used there. but it just relates to the level of the harm that's been caused and the number of people that you have to, the number of relationship levers that have to bring to be brought in to manage the problem in a good way that keeps people out of harm's way. But in terms of that, we know from a number of different jurisdictions that in the context of schools that use restorative practices in a whole school model have lower suspension rates. And that's an indication that there's lower recidivism rates. But in the terms of more rigorous trials of recidivism, we know through the RISE studies that are currently happening in England right now that recidivism rates always go down. In terms of big meta-analysis of restorative justice on top of, say, a criminal justice process, like post-sentencing, we know that recidivism rates go down for serious crimes as well as property crimes.
Very good.
Does that
Other
help?
questions? Yes.
Does that,
Okay, we'll take another question from